Ever get that sinking feeling when you think about who might have a key to your front door? That little niggle of worry about unexpected drop-ins, or maybe demands from your landlord or property management?
We've all been there, I think. That feeling of not quite having full control over your own living space.
Exactly. And, that feeling isn't just paranoia. It often reflects a real power dynamic in rental situations.
Absolutely. Today, we're diving deep into a listener's very real and, frankly, pretty frustrating run-in with their property management company. It sounds like quite the ordeal.
It really does. They experienced an unauthorized entry into their apartment,
Hmm.
followed by pressure to move out early.
And now they're facing disagreements over penalties and what seem like, well, excessive charges for damages.
Right. And this isn't just hearsay. We're digging into solid information today.
Sure.
Our exploration is based on legal guidelines that specifically address these kinds of rental disputes and the responsibilities of property management companies.
hmm Think of this as your shortcut to understanding the key legal principles relevant to this kind of situation. No need to wade through dense legal texts yourself.
Our goal is pretty straightforward: to give you, our listener, the knowledge you need to understand your rights when facing a rental dispute like this one.
Yeah, we want to help you navigate these confusing situations, maybe spot potentially misleading tactics, and ultimately feel, confident in seeking a fair outcome.
Consider this your fast track to being legally informed. Okay, let's unpack this, starting with what must have been a real shock for our listener: the unauthorized entry.
Right. They returned home to find property management staff had simply let themselves in without permission.
Wow. That immediately brings to mind a fundamental aspect of tenancy, the tenant's right to what's often called quiet enjoyment.
Exactly. It's essentially the right to live in your home without undue disturbance. Now, while our source might not use that exact
Hmm.
phrase, it strongly emphasizes the landlord's obligation, and this definitely applies to their representatives, like a property management company to provide a habitable dwelling.
Which means ensuring it's suitable for living. Right.
Precisely. And that inherently means respecting the tenant's privacy and their right to exclusive use of the property as outlined in the lease agreement. You can't just walk in.
So someone just walking in like that,
Hmm.
that feels like a major violation, a huge breach of trust.
It really does.
Here's where it gets really interesting.
hmm
Could this intrusion alone be a valid reason for our listener to end their lease early, without facing penalties?
That's a critical question. And well, while the source doesn't explicitly state unauthorized entry automatically terminates the lease, it does hint at something important.
Okay,
It indicates that if the actions of the landlord or their agents make the property unsuitable for living, the tenant might have grounds to end the lease early.
I see. So an entry without permission, that certainly raises serious questions about the tenant's sense of security and, well, peaceful living in the property.
Definitely. It could potentially make the place feel unlivable for them.
Now let's figure out who's responsible here. The property management company seems to be trying to pass the buck.
Suggesting our listeners should pursue the individual employee who entered their home.
Yeah, exactly. That's the kind of runaround nobody wants.
Well, this is where a crucial legal principle from our source becomes really important. It clearly states that rental housing service companies are liable for damages resulting from their failure to uphold the contract.
Liable themselves, not just the employee.
Right. Specifically, the source highlights something called vicarious liability, which basically means a company is jointly responsible for the intentional or negligent actions of its employees
Okay.
when those actions occur while they are performing their job duties.
Jointly responsible. Okay, let that sink in. So the idea that the company can just say, not our problem, sue that person, that doesn't really hold up based on this principle.
Precisely. The source explicitly says the rental housing service company should jointly bear the liability with its employee if that employee's actions during their work cause harm to the tenant.
So the company's attempt to shift all responsibility to the individual employee likely contradicts these legal principles. They can't just wash their hands of it.
It certainly seems that way based on the guidelines.
Right. Now, understandably upset by this intrusion, our listener immediately wanted to move out. Makes sense.
Absolutely.
They contacted the property manager, who, to their credit, initially apologized and actually agreed to let them terminate the lease.
Okay. But then things took a turn, you said.
Yeah, it seems so. But what's fascinating here is this initial communication. The listener's immediate expression of wanting to end the lease,
Mm-hmm.
combined with the property manager's apology and agreement, could potentially be interpreted as a mutual agreement to terminate the lease, couldn't it?
That's a really interesting point. In contract law, if both parties clearly intend to end the agreement, a sort of meeting of the minds, that agreement itself can be legally binding.
Right. And our source mentions something similar regarding settlement agreements reached in mediation. Remember that?
I do, yes.
Even if a judge hasn't formally approved it, if both parties agree on a resolution, it's generally considered binding.
Exactly. We can draw a parallel here. While this wasn't a formal mediation setting, the documented communication showing agreement to terminate could be argued as a similar kind of mutual understanding.
So that could suggest the lease was ended by mutual consent, not solely by the listener breaking the contract. A strong point for the listener.
It potentially could be, yes. It's certainly an argument worth making.
But even if that argument isn't completely successful, there's another angle to consider, right?
Hmm.
If the intrusion made the apartment feel unlivable,
Hmm.
and it's clearly the property management company's fault through their employee,
Hmm.
couldn't we argue that they breached the contract first?
Absolutely. That's another key perspective. The source indicates that if a tenant can't continue living in the property due to reasons that are not their fault.
Like an unauthorized entry.
Exactly. And if the property is therefore not suitable for living, perhaps due to that loss of security and peace, they can end the lease early without having to pay any compensation.
Okay, so if the intrusion is seen as a significant breach by the company
Yeah.
or their agent,
Then the listener could argue they ended the lease because of the company's breach, which would, in theory, negate any penalties for early termination.
this leads us nicely to the financial demands they're now facing. They're asking for a penalty for ending the lease early A&D rent for the period after our listener moved out, but before the official handover.
Right, let's tackle that penalty first.
Okay.
Our source is actually quite clear on this point. Even if a tenant does initiate early termination voluntarily, any penalty stipulated in a standard lease agreement cannot exceed the equivalent of 1 month's rent. There's a cap.
Okay, only 1 month's rent max. But
And this is crucial.
if the termination wasn't initiated by the tenant's voluntary breach, if it was due to the company's actions making the place unlivable, or by that mutual agreement we discussed, then this penalty likely shouldn't apply at all, should it?
That's the logical conclusion based on these principles, yes. The penalty is typically for when the tenant breaks the lease without sufficient cause.
That makes sense.
Huh?
Okay, and what about the rent they're demanding?
Yeah.
For the time after our listener moved out, but before they officially returned the keys.
Well, that demand is based on the assumption that the lease is still technically in effect during that period.
Right.
But if, as we've discussed, the lease was already terminated either through that potential mutual agreement right after the intrusion or because the company's breach made the property unsuitable,
Then the obligation to pay rent after they vacated might just cease.
it might no longer be valid, correct? Now, the fact that the listener spent 3 weeks cleaning and moving is a factor to consider in the timeline. But the responsibility for rent during that specific period really hinges on the exact termination date and whatever was agreed upon, or what the law dictates if there was a breach by the company.
Got it. Lots of ifs, depending on how that termination is viewed legally.
Precisely. It all ties back to why and when the lease effectively ended.
Okay, let's switch gears a bit and talk about the damaged furniture. This adds another layer to the dispute.
Mm-hmm.
Our listener is willing to pay for the damage caused, which seems fair enough, but the company is insisting on the new replacement cost.
Ah, not the current value of the used furniture.
Exactly, and it doesn't sound right, does it?
No, it generally doesn't align with the usual legal principle here, which is often described as restoration to the original condition before the damage.
Okay, what does that mean in practice?
Well, generally, compensation should cover the cost to repair the item if possible, or if replacement is necessary, it should cover the item's depreciated value.
Depreciated value,
Meaning, the current value of the item, taking into account its age, how much it's been used, normal wear and tear, not the cost of buying a brand new one off the shelf.
So, if you've been living somewhere for 6 months, like our listener has, that piece of furniture isn't brand new anymore. It's seen some use.
Of course. It's experienced 6 months of life, meaning its current value is almost certainly less than its original purchase price.
Right. So demanding the new replacement cost probably doesn't align with the principle of compensating for the actual financial loss incurred. The loss is the value of the used item, not a new one.
Exactly. The furniture has depreciated over those 6 months, and that depreciation should absolutely be factored in when determining a fair amount of compensation. Asking for the new price seems like asking for betterment.
This has been incredibly helpful in sort of understanding the legal background here. So for our listener facing this, what practical steps should they take next? Where do they even start?
Okay, the first and probably most vital step is evidence collection. Gather everything.
Everything.
Everything. They mentioned having messages from the property manager apologizing and agreeing to the lease termination initially. Gold dust.
Right.
They need to save and organize every single piece of communication, text messages, emails, voicemails if they have them, anything that supports their account of events. Timestamps, dates, who said what.
Okay, meticulous documentation. That could be crucial evidence in resolving the dispute, I imagine.
Absolutely crucial. Document everything.
Got it.
What else should they do?
Okay, next, they should consider sending a formal written notice to the property management company.
A letter. Yes, a formal letter. And it's best to send this via certified mail or some method where they have proof that the company received it.
Proof of receipt, good tip. What should be in this letter?
Well, it should clearly outline their position. So state the facts, the unauthorized entry, and how it violated their right to peaceful living. Then state their position that the lease was terminated either due to this event, meaning the company's breach of contract, or by that mutual agreement referencing the saved communications. Lay out the arguments we discussed.
Exactly. It should also clearly explain the company's responsibility for their employees' actions, maybe even referencing the regulations about vicarious liability if they feel confident.
Okay.
Then, a firm rejection of the penalty and any rent demands after they moved out, reiterating why, because the termination wasn't a voluntary breach on their part.
Right. Connect it back to the company's actions or the agreement.
Yes. Then, address the furniture, state their willingness to pay reasonable compensation based on its current depreciated value. They could even ask for documentation, like repair estimates or evaluation of the damaged item from the company.
Put the ball back in their court on that.
Precisely.
Yeah.
And finally, maybe propose a date for the final property handover, stating that if the company doesn't cooperate reasonably, they'll proceed according to the lease terms regarding handover, but will reserve all their legal rights.
Wow, that's a very thorough letter. Covers all the bases. What if the company still refuses to cooperate after receiving that? If the company continues to push back or maybe ignores the letter, the listener should seriously consider seeking mediation.
Mediation. How does that work?
Well, our source points out that local or national associations of rental housing service companies often have processes for this. And importantly,
Yes.
this property management company, if they are a member of such an association, likely cannot refuse to participate in mediation. These associations are often obligated to help resolve disputes involving their members.
Oh, interesting. So the company might be required to come to the table.
It's a strong possibility, and mediation can be a much less expensive and time-consuming option than going directly to court.
So it's like having a neutral third party help facilitate a discussion and hopefully help both sides reach some kind of agreement.
Precisely. It's a structured way to try and find common ground, guided by someone impartial.
Okay, that sounds like a really worthwhile step.
And there's another related point. Our source touches on security deposits, but also mentions that rental housing service companies may be required to contribute to a kind of guarantee fund.
A guarantee fund.
Yeah. So if the listener were to, say, win a judgment in court or reach a formal mediated agreement and the company still failed to pay what was owed, they might be able to seek compensation from this fund under specific circumstances. It's another potential safety net, depending on the rules.
That's good to know, another potential avenue if things get really difficult.
Yeah.
What if mediation isn't successful, or they feel they just need more direct legal action?
At that point, seeking legal consultation is really the next logical step.
Talking to a lawyer.
Yes, or perhaps a local consumer protection agency that deals with housing issues. They should gather all of their documentation, that evidence collection is key again, and get professional advice tailored to their specific situation and location.
Right. And what about the company's warning about a lengthy and costly lawsuit? That sounds intimidating.
It is intimidating, and maybe intentionally so. But it's important for the listener to remember that these are just, well, arguments or threats to be presented in court. They aren't predetermined outcomes.
Good point. It's not decided until it's decided.
Exactly. The court will ultimately decide on the validity of the lease termination, who bears responsibility for what, and the appropriate amount of any damages based on the evidence and the law.
And it's also worth keeping in mind, isn't it, that these standard lease agreements themselves aren't always ironclad.
That's right. As our source indicates, these are often standard form contracts governed by regulations.
So any clauses within that lease that actually violate those regulations, like maybe excessively high penalties beyond that 1-month cap we talked about, might actually be legally invalid anyway.
Correct. Just because it's in the lease doesn't automatically make it enforceable if it contradicts established legal protections for tenants.
Okay, so just to summarize for you, our listener, remember, your right to quiet enjoyment is significant. That peaceful living in your own home.
hmm And property management companies are generally responsible for the actions of their employees when they're on the job. That vicarious liability point.
You have strong arguments against the demands for that early termination penalty, especially if the termination stemmed from their actions or a mutual agreement.
And also against paying the full new replacement cost of the damaged furniture. Compensation should generally reflect the actual loss, considering depreciation.
And your immediate next steps. Focus on documenting everything meticulously. Send that formal written notice outlining your position clearly.
And definitely explore mediation through the relevant housing association. It could be a very effective route.
This situation really highlights how important it is for tenants, for you, to be aware of your rights. And crucially, to not feel intimidated by potentially inaccurate or misleading claims from landlords or management companies.
Absolutely. Understanding the relevant legal principles, even just the basics we've discussed, can be a powerful tool in navigating these kinds of disputes fairly. Knowledge is power here.
So, considering all of this, thinking about your specific situation, what feels like the most empowering first step you can take right now to resolve this?
Yeah, take a moment to think about this information and decide on your first course of action. What feels right for you?
And remember, understanding your rights as a tenant is valuable knowledge, no matter your current renting situation. It's always good to be informed.